This is actually a new topic. We've never talked about it in the landlord workshop. There seem to be themes and topics we talk about over and over again, like at the beginning of today's, we were just sort of chit-chatting with Hadi, maintenance. Of course, maintenance is something that comes up every single day. And that's why we talk about some topics over and over again, but we haven't ever talked about domestic violence or these similar types of situations in rental housing. One reason is hopefully this doesn't have a high occurrence in the rental housing industry. In other words, you haven't really come across it too much. And then the other reason is we sort of advocate for not getting involved in our tenants' personal lives. I mean, all we should care about as landlords is my tenant paying my rent on time? Are they taking care of my property, not damaging it? And are they a good tenant? Are they, behaving themselves? Are they not causing disruptions to the other tenants on my properties? Are they not, bothering the neighbors, being good community members? We don't really we shouldn't really care about their personal life, what goes on in there. And I guess domestic violence sort of falls in there. I mean, it's terrible that it does occur in some people's lives, and we tend not to find out about it, and we really shouldn't be involved in it. However, we should be involved in it if it comes to our attention, because there are specific laws about domestic violence that we as landlords need to understand how to handle if the tenant ever does, bring it to our attention, because there are going to be implications for letting the tenants out of the lease, changing locks. There's just a lot of laws that's surrounding it. So I thought it'd be a good idea for us to cover that in case the situation ever comes up for you. So let's go through the presentation today, and I'll give you the answers to these. But just very quickly, do the landlords have to let the tenants who report domestic violence out of these? Yes, but they have to meet certain conditions, and that's what we're going to talk about here today. What are these conditions? Tenants who end the lease due to domestic violence are responsible for the rent. Are not responsible for the rent. So this was a question that was almost evenly split between yes and no, or false. So if you guys got the answer wrong, that's a really good learning here for you today. And then, do they have to experience physical harm? Nope. There's other types of harm. So we'll show you here today. Do they have to provide proof? Some of you guys said yes. Some of you said no. It was a little bit of a trick question because it sort of depends on which type of harm, and I'll show you. And then most of you got it right, where if the landlord does have to change the locks. So it was a really good pretest, I think, to show you guys. I think it's a really good idea for us to review the laws, because there was a lot of you guys who are not familiar enough with it to deal with it if you come across that situation. Okay, so let's dive into the specifics here now. There are two laws we're going to cover here today that talk about domestic violence and housing. The first one is called the Safe Homes Act, and this is actually a law that was passed in Illinois. So it's been in effect since 2007, but like I said, we really haven't talked about it here, so it's a good idea for us to cover it. And the Safe Home Act is important for us to know that it covers private housing. So it covers everybody on today's call, but that does include Section 8. It does not cover public housing. The second law we're going to talk about here today does cover public housing. So we'll talk about the Safe Homes Act first. And when I talk about the following slides, I'm just going to say tenant, 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 but it's important to remember that the Safe Homes Act covers not just their tenants, but family members, and especially the children who live with them. So what the Safe Homes Act is designed to do is to reduce domestic violence. And it gives the tenants an opportunity to get out of that dangerous housing situation. There's maybe a violence or abuse that's going on. It allows them to flee that situation. They're safe, and that way they won't get injured. And this is why I spent a little bit of time talking about all the bad things that happen as a result of violence. We know that one of them is it just has really bad economic repercussions for them, where they lose their jobs, they lose their housing. So they want to get rid of some of these bad things that happen as a result of domestic violence. The law covers 3 different areas, and this is what we're going to talk about today. And this is sort of one of those trick questions that I asked in one of the poll questions. So there is domestic violence that is future harm. It's going to happen, could happen in the future. There is domestic violence that has already occurred. In other words, the tenant has already experienced it. And then there's a section of the Safe Homes Act that covers the changing locks. So let's take a look at those 3 different parts of the law that cover domestic violence. So the first one falls under the little category here of future harm. What does the word future mean? could occur in the future. So according to the law, what it says that the tenant has a credible, imminent threat of domestic or sexual violence at the property. So what this means is that the tenant doesn't necessarily have to have already experienced some sort of incidents of domestic violence. Somebody beat them up, somebody threatened them, or something like that. It is a possibility that something is going to happen in the future. Well, I probably should have underlined this one too. So it has to be credible. Just because something happens in somebody's mind doesn't mean that it's going to happen. So the tenant has to demonstrate that the threat is credible. It's imminent. Somebody threatens you, I'm going to beat you up next week or something like that. It's not just, oh, this vague threat in the vague future. And there's two types, it's domestic or sexual violence. So if the tenant has credible, immediate threat of domestic or sexual violence, what that means is the tenant can break the lease. They can move out of your property, and this is the answer to one of your guys, the poll questions there. They are not liable for rent. I know that's hard. That sucks for us landlords, but hopefully, we understand that this domestic violence is not the tenant's fault. This is a terrible situation. We should not have to hold them liable for something that's beyond their control and that they are a victim of. So landlords are not cannot charge tenants for cannot hold the tenants liable for any any rent due under the lease if they are victims of domestic violence or sexual violence. But that does not excuse them for any past due rent. So let's say the tenant has been behind 6 months in rent, and you file for an eviction, and then all of a sudden tomorrow they say, oh, I am, victim of sexual abuse, I'm breaking the lease. It will go through the requirements here, but if you say, okay, I'm letting you out of the lease, that does not release them from any past due, violations, any past due rent. If you've already filed for the eviction, you can go forward with it. And then the other thing to remember here is that it's at the rental property. And what the law encompasses for the rental property is they say that this means anywhere that's owned or controlled by the landlord. So this can be inside the rental property, the apartment or the house, but it also covers common areas, entrances, any outside areas. I just put yard there as one example, or the parking lot. So it's not just in property, it can be anywhere. Sandra said, not liable for future rent. Yep, you're absolutely right. And again, this is one of the answers for the poll questions, and almost half of you were incorrect about this. So this should be a really big, hopefully, takeaway from today's meeting is tenants are not responsible for the future rent. Now, what do they have to do? They just can't say, oh, I'm a victim of sexual abuse, see ya. They do have to give you written notice. In that written notice, it has to clearly state, I'm ending the lease. Why? Because I have a credible, imminent threat of future domestic violence or sexual violence. Now, how many tenants are going to actually write that phrase? I don't know. But as long as they sort of communicate to you in some way, shape, or form what's going on, we should accept it. And there is a timeline. They need to give you that written notice before they move out or within 3 days after leaving the property. This was another question here on the polls is, does the tenant have to give you proof that they have been victims? No, not in this case. So if they're saying, oh, hey, there's a chance in the future something bad's going to happen to me, this is kind of difficult for us to accept as landlords, but they don't have to give us any proof. And so in other words, if you are a landlord and the tenant says, hey, I'm going to move out, you can't tell them, give me a police report, give me a court order. You cannot demand any type of evidence whatsoever. Again, this is difficult for us, but they're trying to be fair to the victims, I guess. Okay, so that's the first type. Hopefully everybody understands that one. Now we're going on to the second type that's covered by the Safe Homes Act. And this is if the tenant has already experienced the harm. So something bad, some incidents of violence has already occurred to them. So if the tenant has experienced, and this one they limited it to sexual violence only on the rental property, this is where the tenant can end the lease. Now, I don't know if this was meaningful on the part of the legislators who created the law. In other words, they limited this experienced harm or the second part of the law only to sexual violence. They do not include domestic violence. I'm not familiar enough with the topic, or on the inside to know, did they purposely just omit domestic violence, or did they accidentally do it? I don't know. So we're just going to have to deal with the law the way it is, and it's just for individuals, tenants who have experienced sexual violence. If they have already had some sort of incident about sexual violence and they let you know about it, same thing. The tenant can break the lease, move out of the property, and again, they're not liable for rent. So it doesn't matter if they think something bad's going to happen to them or something bad has already happened to the tenant. The landlord, we landlords cannot charge them future rent. And then just as a reminder, this can be anywhere that's owned or controlled by the landlord. It's not just limited to their like apartment, etc. Again, the tenant is responsible for giving the landlord written notice. In this one, we just like the other one about the potential future harm, they have to tell us landlords, I'm ending the lease. Why? I'm ending the lease because of sexual violence. And now this one is different because they do have to give us specifics. They have to let us know when the sexual violence incident occurred. And this incident can't be more than 60 days before that tenant gives us the notice. But they do give us the tenants a little bit of leeway. If the tenant has been hospitalized for a while or they're had to move out and go into emergency shelter, they try to give the tenants a little bit more time. And then again, getting back to that poll pre-test question, I asked whether do they have to give us proof or not. It does depend. For the future harm, nope, they don't. But this one, they do have to give us proof. And the tenant can give landlords either a police report, their medical records, court records, or if they've gotten help from some sort of organization, a statement from them will suffice. Okay, so this is really big difference between whether a tenant has undergone harm or experienced harm versus the future.